to the 7th in our Invest Atlanta live series for startups and scale-ups here in the city of Atlanta. These sessions really are comprised and made up to allow us to provide timely, relevant, and inspiration to the community during these challenging times of COVID-19. I'm Dr. Eloisa Clementich, President and CEO of Invest Atlanta. Invest Atlanta is the economic development arm for the city of Atlanta, and we invest in people and communities and companies here. Our economic development team supports everything from business attraction, retention, expansion, small business, community development, housing, and obviously a very important sector is our technology and creative and startups here in the city. During this COVID-19 pandemic, we are focused on bringing resources and support to the community of innovators and entrepreneurs that we are so proud of, that you guys call Atlanta home. To that end, we have partnered with the startup ecosystem to bring you these information sessions. So I thank many of our sponsors who support this. I'd like to recognize our staff and thank both Nathan and Amy for their leadership and everything they've done to support these. I'm really excited. And today I just had to join this special session because we are going to be hearing from some of my most favorite individuals within this cluster. We will be able to speak with today with John Yates, with Morris Manning, with Larry Kuhn and Eleanor Stone. And the session will be moderated by, nonetheless, one of my most favorite, Larry Williams at TAG. And with that, I hope and wish all of you the best. And again, want to thank each of you for your contributions to the city and for your continual support in everything you do within this entrepreneur ecosystem. Thank you. Larry, off to you.
Well, thank you, Eloisa. Delighted to have always partnered with you. And of course, you're one of my favorite people as well. So we're always delighted to partner with our good friends at Invest Atlanta. I want to personally thank you for your leadership and all you do to make sure that Atlanta stays as one of the top world-class cities in the world, that position that we have. And people continue to know that we are one of the top technology states as well as top technology cities really in the world, and really think about Atlanta as a global hub for innovation. My name is Larry Williams. I'm the president and CEO of TAG, the Technology Association of Georgia. And as I mentioned, we're delighted to be here partnering with Invest Atlanta and our friends at Morris, Manning, and Martin. At TAG, we really do focus on how do we connect the technology and innovation ecosystem throughout the state of Georgia, and making sure there's great ways for people to create the networks and the opportunities they want so that companies can not only thrive here, but they can continue to start new companies and that those companies can grow and be successful here as well. At TAG, we've been working very hard at making sure there's a lot of connectivity. A lot of what we do is around workforce and preparing the workforce needs of today and preparing the workforce of the future. And a lot of that's through our STEM education initiatives that we do through our foundation and other coding camps, internships, and other work. To keep our network engaged, we've been working. We had over 28 virtual events of engagement in April, and we're looking forward to bringing more. And then, of course, bringing great partner events like this one on. I want to start by giving everyone an opportunity of our panel to introduce themselves. As we think about reopening your workplace, this is extremely important to everyone. I know, people are eager, they want to get back to work, but we want to do so in a safe and secure environment. And that's what the experts here can help us think through. And I'm going to guess and say there's probably not a one size fits all. And so taking some advice about what we can do and how you can apply it to your own situation is going to be very important. So let's just do a quick self-introductions. And Eleanor, I'd like to start with you. Would you introduce yourself, please?
Thanks, Larry, and thanks to everyone at TAG. We're really happy to be here. I'm Eleanor Stone. I'm a partner at Morris Manning in the Employment Group. We've been doing a lot of work lately with return to work issues. We have a coronavirus task force that has been looking at this issue as well as a lot of other issues with coronavirus and how it affects employers and how it affects all aspects of businesses. And then I'll turn it over to my colleague,
Great.
Larry.
Yeah, Larry, please introduce yourself.
Larry, I think you're muted.
It's funny. I thought I was on
There you
mute, and I hit the button, and I actually muted myself when I wasn't muted in the first place. Well, good morning, everybody. I hope everyone's safe and healthy. Hopefully, we don't get too confused between two Larrys on this call. I'm Larry Cunin, or Larry K. Could probably be an easier way to refer to me. I'm a partner in Morris, Manning & Martin. I've been with the firm for over 20 years. And I am in the litigation group, which means more than just lawsuits. It means dispute resolution and avoiding dispute resolution. Way back in another time, I was actually in the technology field myself as a computer programmer, analyst, and designer. Not the stuff we're doing today, but I have that particular aptitude. And more recently, as part of what's going on with COVID-19, been involved with our clients, especially technology clients, with regard to issues that are popping up with customers, landlords, vendors, sponsorships at events, etc. And so hopefully I could provide some useful information to everybody today. Look forward to it.
Excellent. And John Yates, please introduce yourself.
Thank you, Larry. I'm John Yates. I head the technology practice at Morris, Manning & Martin. I have the pleasure of working with Eleanor Stone in the employment area and Larry Cunin in the litigation area. We represent 300 plus tech companies, a lot of them in the Atlanta area, and have the good pleasure of being involved with TAG and working with Larry Williams.
Well, thank you, John, and you're a great board member of TAG as well. Hey, to get this conversation, I really want to start off with a question for you, Eleanor. And I think to frame it up, what should employers do first when deciding if employees can return to work?
So first, it's important to see if you can even open at all under, state and local orders. And then if you can do that, it's important to see if it's practical for your business to do that. So some employers, once they've determined that they can open, they have decided to bring back a skeleton crew, or they've decided to bring back workers in staggered shifts. Now, if you do bring back workers in staggered shifts, that can raise wage and hour issues for some employees who are salaried workers. That's something to consult with an attorney about. Beyond that, it's above all, it's really important to have a robust health and safety plan, which I believe we'll be talking about later, so that when you're very prepared for when your workers do set foot on the premises.
Okay, that's great, Eleanor. Hey, Larry, following in on that, what is the potential liability of reopening? Can you talk about some of those concerns people should be thinking about?
Yeah, and I'd like to say something as an introductory statement. And I say this somewhat facetiously, but everybody has seen all the commercials that have been running for years in our Sue Happy Society. Have you taken this drug? Have you used Roundup? Have you, had some kind of asbestos infection, etc.? And these claims will pop up. And one of the jokes that's running around now is that in about 5 years, you're going to start to see commercials that say, during COVID-19, did you get COVID-19 while wearing a face mask? This number. Well, what's the point? The point is, if you want to be liability free, you need to lock yourself in your house, not drive your car, not engage in a business. Basically, don't go out in public, and you'll be liability free, or at least as close to it. Everything you do in your life is going to create some risk of liability, or some risk that a lawyer is going to find a way to seek liability against you. So there is no way that I could say would eliminate liability related to restarting your business. The issue comes down to best practices, following government guidelines, maintaining your social distancing, and if possible, have insurance, and we can touch on that a little bit later. Protect yourself against the potential for liability, or what may happen if one day a complaint shows up on your doorstep. And what we're talking about here is, as businesses open, that means vendors are going to come on the premises, that customers are going to come on the premises. Some are going to be wearing gloves, some are not going to be wearing gloves, some are going to be wearing face masks, some will not. You'll have rules posted. Somebody gets sick, and it's very predictable that if somebody gets sick, somebody's going to try to tie that back to every business that they have had contact with. So if you've got a business where somebody comes into a conference room, that's be a situation you may face.
Larry, let me stick with you on this with a follow-up on that, because I think it does flow into the rest of the conversation. As I play amateur lawyer, there's always been the reasonable person principle. What is it that an employer and a reasonable person and actions that they would take? So can you talk a little bit about what types of litigations may have been filed to date or expected to be filed as the economy, and a little bit about, what is this reasonable person principle?
Larry, you're muted.
Oh, I did it again. No, I'm not muted. You can't hear me?
Can hear you now.
Okay. I was going to first say that with regard to the reasonable person standard, which is a standard we hear a lot about in court, people ask me, well, what's reasonable? And my usual answer is reasonable is what the jury tells you it is on the day that they tell you what it is. Because what's reasonable in one circumstance may not be what's reasonable in another. And a lawyer's job is to make arguments for and against what that standard is. And so what we're already seeing, and I'm not sure if the reasonable standard applies to this, but almost immediately when businesses start to get shut down, we've been tracking kinds of cases that have been filed around the country. And as I mentioned, we're already anticipating that when businesses reopen, we can expect, not immediately, but over time, we're expecting to see cases related to exposure to COVID-19 or other things that got in the way of people's lives. But we've seen things, everything from an insurance company has denied coverage for business interruption. We've seen lawsuits against universities because people have been studying at home and they didn't pay tuition to study at home. Lawsuits against the government about shutting down parks, for example, for no reason, because you can maintain social distancing. There have been lawsuits about conventions, events that have either been canceled or refused to be canceled, and deposits refused to be returned. Lawsuits in real estate and lease transactions where somebody was either allowed to engage in the transaction that they shouldn't have been allowed to and they want to back out, or that they were not allowed to complete the transaction that they had a contract for. It really is a very, very broad brush. In the short run, I'd say the vast majority of these cases look like they're opportunistic plaintiffs' attorneys. We do have two in this world, and there are a lot of plaintiffs' attorneys out there, and nothing negative against them other than they're trying to make a living. And they'll file claims that are worth not much money, hoping that they can get a quick payoff because it's just not worth paying litigation. So when a client asks me, didn't I act correctly? I didn't do anything wrong. Didn't I act reasonably? Didn't I follow whatever? That doesn't stop somebody from filing a claim. And then the company has to do this weighing thing about, do I just do a quick, cheap payoff or do I fight it in an expense that costs more to fight it? And again, insurance may or may not help with that. And I think we're going to come up to a question about that in a little bit.
Yeah, well, that's good. And Eleanor, why don't we talk a little bit about, how do we stay out of the courts, and what sorts of screening options do employers have to test employees, and, creating that safe and secure work environment that everybody wants.
So along with what Larry was talking about with the kinds of cases we're seeing, what I'm seeing in the employment context are cases where employees are saying, you knew that we had coronavirus, you knew that you had employees with coronavirus and you did nothing about it. So it's important to know that employers are well within their rights to go up to employees who have recognized symptoms, or at least one recognized symptom of coronavirus, and ask, hey, do you have coronavirus, or have you gotten that checked out? Have you gotten that cough checked out? But it's also important to know that employers cannot go up to someone who is of advanced age and ask that same question unless that person also has a recognized symptom of coronavirus. So that's one way that employers can mitigate risk, is to do these ongoing screenings. That's a type of screening. Paying attention to what's going on in the workplace. Are your employees coughing all the time? You need to be doing something about it. You're never going to get the risk down to zero, as Larry was mentioning. That's not expected, but you need to be monitoring. In terms of screening, you can take temperature checks of your employees on day one. You can take temperature checks daily. You can, and you can do that of anybody else entering the premises. If anybody says, I don't want to do that, you can send the person home. The same goes if anybody refuses to answer any of your permissible COVID-related questions. Like if you ask someone, hey, have you gotten that cough checked out? You can send the person home if the person doesn't want to answer. You can ask someone to take a blood test. But this, the EEOC cautions, you better be careful if you do that, because these blood tests are not perfect, as we've all seen on the news. You can ask employees to give a self-certification that they have not been around anyone who's been sick with COVID. They themselves have not been diagnosed with COVID, and that they do not have symptoms of COVID. Or you can have that done through a doctor as well. But of course, that, as EOC has recognized, that's going to be hard to do now with how busy doctors are. And we talk about having people come back to the workplace and having these tests on day one. But again, this really is an ongoing obligation, because if you just do it on day one, and then you don't do it again, you're not really meeting that ongoing obligation. That would be a problem. And then in terms of your question about keeping the workplace safe, I find it helpful to think about it in the way that OSHA talks about it. OSHA gives us a 5-part framework. And they say this goes from most effective to least effective, and how you can make a safe workplace. Because every employer has a general duty to make the workplace free from risks that are likely to cause death or serious physical harm, which we could probably say about COVID here. So the first is hazard elimination. That's keeping everybody at home. And, that probably is not going to be feasible for every employer, maybe feasible for some, but not in the long term, certainly. The next is personnel substitutions. That's having a skeleton crew. Again, long term, probably not so great, but works okay now for some people. And then going down the list, we have engineering controls. That's when we're back in the workplace. And that's the most effective form of controls when we're back in the workplace. So that's things like, it's any change to the environment that removes or reduces, lessens the chance that your employees will contract an infectious disease on your premises. So changing the air filters more often, changing the way the air flows, changing the desks so that your employees don't face each other, putting tape on the ground to show what 6 feet is. And then administrative controls, and that's safe work practices, changing how employees do their jobs, training them on the use of PPE, training them on proper hygiene. Bottom of the list is PPE itself. OSHA says, it's okay. It's better than nothing, but don't rely on it solely. So what an employer can do to reduce the risk of liability, and also just to make the workplace safer, is to say, hey, I followed OSHA's general duty clause, which was to make this workplace free from hazards. And I did by performing what OSHA calls a hazard analysis. And it has 3 parts in it. And it's to identify high-risk workers. And OSHA has said in the context of coronavirus, that's people of advanced age, people who traveled recently, and people who have certain medical conditions. And then I identified potential exposure sources. So I went around and I said, maybe they're touching certain things more frequently than other things. The drinking fountains, this communal refrigerator. And then I went around and I put in appropriate control measures. I'm not going to let them use that communal refrigerator for a while. They can bring their own lunches. So if you write that down, put it in writing, show it to your employees if they ask about it, that is going to go a long way for not only making your workplace safer, but having something in writing that you can show if you ever need to show it, that you actually were very thoughtful and methodical about taking steps to make your workplace safer. Not completely safe, it's never going to be that, but safer.
That's great. So I'm hearing, a principled approach, make sure that you're communicating what your standards are, and then anything you do across every employee, that it applies to every employee, so you don't get into singling out any protected class. Hey, John, let's move on to our innovation culture, our startup companies, and our investment community. How will all of this impact investors as well as the companies they fund as we start to return to work?
I think there's three impacts there, Larry. First of all, these funds, particularly venture capital and private equity funds, like to eyeball people. And so the idea of reopening an office, as Eleanor and Larry Cunin have talked about, it's important to do it the right way. But a lot of these funds, frankly, are saying, look, until we can actually get an eyeball to eyeball people face to face, we're not going to be making investments. So that's one category. The other category of funds are the ones that say, listen, we're not investing in a lot of new companies, but the portfolio companies we've invested in, they have a lot of cash and they're interested in buying companies. So it's important, if you're a company that might be a target to another larger company, that you followed what Eleanor and Larry Cunin have talked about here, to do it the right way, following best practices and opening your office. Because any investment now is going to include a series of representations and warranties that you, as the company that's selling your stock, have followed those requirements. And so, as Eleanor and Larry Cunin have pointed out, there are a lot of requirements in opening your office. And if you do it the wrong way and you have liability, it could stall or prevent a deal from happening. And then there's some funds that have basically said, look, this is a heyday for us. You know, we got a lot of capital. We just closed a big fund in January and we're ready to go buy. And we don't care that companies are, basically sheltering or slowly reopening. There are few of those funds out there. Most of them are smaller funds, and most of them are focused on specific industries like healthcare, telemedicine, or distance learning. So it's across the board, but we're spending a lot of time talking to the funds to figure out what category they're in.
Well, John, what about funds that are in one state and yet the company that they're investing in is in a different state? Are they going to be managing everybody to California or Massachusetts standards, or are they going to be managing to the other standards?
It's a great question, and I'll answer quickly, and then I'll ask Larry Cunin maybe to pick up on that because it relates to litigation questions too. Most of these funds are agnostic when it comes to geography. They will invest anywhere. As a matter of fact, a lot of them, even in Silicon Valley and Boston, will invest anywhere except Silicon Valley and Boston because the valuations are so high. So what you see are situations where these funds now, I think, initially may have some reluctance, unfortunately, to come to a state that has wide open regulations or a lack of regulations with regard to sheltering. We've already seen that a bit by folks that frankly don't want to come to Georgia right now because of some of the open environment that we have. But we also see some issues that are going to arise with regard to, you got a fund that's in another state and investing here. What standards are they going to apply? And Larry Cunin, you might want to pick up on that because that's going to be an issue that's going to arise certainly in the context of disputes.
Yeah, so I really to the front end as much as John can as far as when somebody's going to invest. But the statement that John made with regard to representations and warranties, that's something I do expect to see in M&A agreements, or investment agreements. We see in my group see those after the fact. And so the first thing we do is we look at what representations were made, what due diligence was done. And I would expect, but again, I'm not involved in the front end, that any investor or acquirer would want to look at what did you do during the COVID-19 crisis to protect the company against liability. Now, one of the first things people are probably going to look at is what were the government regulations in force at the time, because one of the defenses that will arise is if somebody got COVID-19 or if I was at risk of somebody getting COVID-19, but I followed the guidelines that my government and the CDC gave me, I'm in a more defensible position in that particular case. So if I'm in a state that's very, very strict, I actually may face more liability if I don't follow the strictness of the case than if I were in a case that were strict. And I followed those less strict guidelines because my primary defense would be I did exactly what you told me to do.
That's great. Hey, we got some questions that have come in over the chat. One of them I see is a follow-up to some of the advice before. And the question is, if you send an employee home because he or she doesn't want to answer a COVID-related question, do you have to pay their salary?
That's a good question. So if the employee, it depends on if the employee is going to be working from home or not. If the employee is going to be doing any work from home, then you need to pay the employee. Probably the employee would still be wanting to work from home.
So if they're working from, if you assign them to home, then obviously they should be compensated. But
Yeah.
could you say that you're going to put them on an unpaid leave and without any assignments?
I don't think you'd want to do that. I think you'd want to, get the right answers about whether they have coronavirus or not.
Okay.
And that's again where it's important to, just find out what employees' concerns are, find out why they don't want to be tested. Maybe they have confidentiality concerns, in which case you can explain to them that, all of this information that the company is taking will be subject to the same sort of procedures that the company has for any other medical information. Because a lot of times we think in our employment group that we're going to have employers whose employees are going to be very concerned about what's going to happen with test results. And that's why they don't want to disclose this information. So that's why it's good to open up the dialogue and just, nip the bud right there.
What if they're in a profession where they can't work from home? Like they have to be on a factory line or something like that?
In that case, if you have to send them, if you want to send them for testing, and then you would have to compensate them for the time. You likely have to compensate them for the time away where you're making them go take that test. If you're saying, we need you to take this test, you haven't answered my question about whether you've taken a test. You either need to go do it yourself, or we'll pay you to go to do it. We'll pay you for the time it'll take to go do it.
Okay. We also have a question about someone's reopening their retail business, and they want to know, how do they I think that means exceed. How do they overprotect their real estate assets? Larry, you want to take that one? Put you on the spot.
I'm sorry, Larry, I didn't hear that.
So they're reopening their retail business. How do they overprotect their real estate assets?
All right, so I'm not sure what the real estate assets are referring to. And I know you can't talk live with the person. I did see that question fly by a few minutes ago on the side, and I thought the same thing, which is your own real estate assets. Are you talking about assets like you're a real estate agent? How do I protect them? I don't know if you mean by cleaning them, which, if that's what we're talking about, is compliance, is the constant disinfection, following those guidelines, or if you're talking about from a liability standpoint, which is where insurance comes in, which is if you got real estate assets, sure the real estate assets are properly insured. And there's two kinds of insurance. I said eventually we'd circle back to this. There are a lot of kinds of insurance, but there are two that come to mind that have popped up with COVID-19. One is business interruption insurance, which is where my business was interrupted due to COVID-19. I could tell you there are huge questions about whether these policies apply, because most policies have exclusions against things like viruses and stuff like that for business interruption. But it's liability, and that's you reopen your business and somebody, employee, vendor, customer, bill and make a claim against you. That would fall under general insurance and not the type of insurance that may have an exclusion for COVID-19. And then that'll again bounce back to the question you asked earlier about the reasonableness of my conduct. Did I follow the guidelines? So I misunderstood the question, but I wasn't sure what was referred to as real estate assets in that particular circumstance.
Larry, let me jump in a second. I just had a note just popped up here just as a point of information on that question from the Wall Street Journal. It says a 59-page internal McDonald's memo lays out rules for opening dining rooms, such as cleaning bathrooms every half hour and digital kiosk after each order. So one of the points here is we don't know what the best practice is and what the reasonable standards are, as Larry Cunin has said. But what you do know is that you can take that 59-page internal McDonald's memo, and I can almost guarantee you it's been gone over by a boatload of lawyers. And if you look at that and you follow some of the constraints and restrictions in there, you can at least come back with a defense that says if somebody later tries to hold you liable and say, look, it was good enough for McDonald's, and they clearly got a boatload of lawyers out of New York to put it together. We've instituted a lot of that. So therefore, it must be a reasonable standard under the circumstances.
I could interject. There is a clarification there about the real estate properties that we were just asked about, and it's that they own the real estate properties from a liability standpoint. And so I do think I addressed the two, which is Number one, making sure that you're following the government guidelines as closely as you possibly can. Now, let's face it, nobody's walking around with a 6-yard ruler or a 6-foot ruler or a halo around them, so you don't get within 6 feet of somebody. But following whatever are the guidelines in place for the local jurisdiction that you're in, number one, and it is unfortunate that it's localized because it is going to be different from place to place. And number two is making sure that your insurance looks good. I will say that I expect insurance companies to be a little suspect right now. If you run out and try to get new insurance, they're going to try to get exclusions for COVID-19 almost certainly. But those are the two ways to protect, which is follow the guidelines.
Hey, so I think people have learned more and have studied more about force majeure than they have in their whole lives and careers throughout all of this. Someone had also told me that there had been an argument with an insurance company. An insurance company denied a claim, saying that since there was no physical damage, that's what theirs did. That's what their coverage was for. But they said, since I physically can't utilize my space, there was physical damage. And didn't know if y'all had heard anything about that or if that got any legs. Eleanor, Larry, any?
I have not.
No.
Okay. Well, that's great. It looks like we covered a lot of the questions here, and I know we're at the end of the hour. Any final thoughts? Eleanor, start with you, or where people can get resources. We've mentioned OSHA. Imagine that's, OSHA.gov. Any other places people can go get resources that might be helpful to them?
Yeah, I'm glad you mentioned that. So OSHA, CDC, EEOC, those are the top three. And the most important thing is that they are updating these guidelines all the time, sometimes rescinding the guidelines. Just last week, EEOC put out something on if an employer doesn't want to, if an employee doesn't want to come back to work, they rescinded that and then took a couple of days to put it back out. So if you're looking at guidance from the EEOC from last month, it very well may be outdated. And they're very careful to say in whatever they're putting out that, this is our guidance as of April X 2020. So that's important to keep in mind. It's also important to keep in mind that everything we're talking about today may be different a month from now. So, but going back to your question, OSHA, CDC, EEOC, are great resources. And also it's important to keep in mind that may not be as applicable for our audience today, but going back to Larry's point, you also need to look at your industry too, because OSHA has specific, industry guidelines. So when we talked about the general duty clause, that's going to apply to everyone who's listening today. But if you're in a specific industry, you might have to follow additional guidance.
Hey, just a quick question that popped up. Edward asked, can I decline to go to work if I feel my workplace isn't safe? And how would that affect my unemployment benefits?
So that's a good question. It would be important to talk to your employer about, why you feel it isn't safe and ask them what steps they've taken. So we're kind of looking at this from the flip side, right? The employer is saying, we're anticipating employees asking that very same question. I don't feel that this is safe. So when employees ask that, we tell employers to find out what are your concerns and, to show the employee, here are the safety steps that the employer has taken. So the flip side is to, tell your employer why you don't feel that the workplace is safe and give them a chance to tell you whether it actually is safe. If it's not safe, then, that's when you go from there. But you should hear them out and see what they've done.
Okay. We got one more question. So let's go with one more question, and then I'll go with Larry for final comments, and then we'll wrap this thing up. Let me see. With the passing of an expanded Patriot Act following the FBI allowing, With the passing of the expanded Patriot Act allowing the FBI to search browsing history without warrant, do any of you know of or recommend a company that enables the private or corporate sector to do the same for employees or contractors?
I think you said you direct that question to me, and Eleanor may know about this too. If I'm understanding the question correct, it really goes to something more general, and I don't think COVID-19 specific. But if we're talking about private or corporate sector being able to monitor the communications or computer use of an employee, a contractor would be a little more difficult, I would think, because I'm not sure you would have access to a contractor's computer. But in general, the employer, if they own the computer and they own the email system that's being used, they do have a right, a policy barring it. They do have the right to look at an employee's emails. They have a right to look at the employee's computer. But if somebody uses, for example, a browser to go to their Gmail, which is private, and then they communicate like with an attorney, for an example, still retain its attorney-client privilege because there's an expectation of privacy in the personal part of the communication that was being done through a browser. So that might appear in the browser history and shouldn't be looked at. But if we're talking about communications that are on the employer's email system, the employer owns that email system. And it's something that we've warned people or have had to deal with in the past, especially in litigation where we go searching for emails, for example, that might be relevant to a subject matter. If we represent the company, we can go through the company's emails. So I think that's answering the question that was being asked there.
Got it. Well, this is the end of our time. Eleanor, Larry, I know John had to drop off. Just thank you so much for your time and your expertise. This has been very helpful. Thanks to everyone who tuned in and participated. Thank you for the wonderful questions. Best Atlanta, thank you for the partnership. I'm going to turn it over to you, Amy Love, to take us home.
Excellent. Thank you all very much. Practical advice, much needed advice right now. Larry, you're a stellar moderator. Thank you so much. We appreciate the partnership with TAG, and we appreciate the partners from Morris, Manning, and Martin joining us today with their expertise. And all of you who joined us live, I know I've noticed some return visitors, and we love to have you on and learning with us and sharing with us. So we record these. We will be sending them back out. We post it on our YouTube channel. We have another one set up for this coming Thursday, May 21st. The time will change. This one will be at 3 p.m. And I'll just cue it up with a theme of refocus and solving problems at scale during COVID with one of the Endeavor portfolio companies. One of our Atlanta area high growth firms will be on with us. And so we're really excited about that. We hope you will join us. And I'll close. I'm sure those of you who join us on the regular can sing along with me, but I always like to thank our partners at the end of these sessions because this is a partnership effort and we couldn't do it without them. So let's get started with that awesome list. Technology Association of Georgia, Larry Williams, thank you again. Advanced Technology Development Center, Atlanta Tech Village, the Metro Atlanta Chamber of Commerce, Startup Atlanta, Innovation Crescent Regional Partnership, Women's Entrepreneurship Initiative, as well as Venture Atlanta, Tech Square Ventures, Engage Ventures, Silicon Valley Bank, Overline Fund, Georgia Alive Initiative, Atlanta CEO Council, Independent Community Bankers of America, MailChimp, and Lab 1886. What an ecosystem. Fantastic support. We really appreciate all of you. Please stay safe. See you next time.